Welcome back, everyone. Today I'll be talking about environmental sustainability. This is a fascinating topic where private property rights meet public interest, where courts become battlegrounds for climate policy, and where philosophical frameworks help us navigate our relationship with the natural world. This isn't just about regulations and compliance. It's about how we fundamentally understand our role as business leaders and citizens in preserving our planet while pursuing economic growth. Suppose you have inherited a piece of property about 2 hours from where you live and work, an undeveloped lot on a lake. It's a beautiful spot, and you intend to build a small summer house on it so you and your family can vacation there. You've been saving up to do this, but after 5 years has passed, environmentalists discover that your property is part of a critical habitat for the spotted green-toed gutter snipe, a species of lizard protected under the Federal Endangered Species Act. This means that you will never be able to build on that land. What is your reaction? If you think this is fair, would you feel the same if you'd paid $180,000 for the property? Or if the gutter snipe was one of 150 lizard species in the state? If you're of the persuasion that you think this is unfair, let's add a layer to the conversation. Your spouse is dying of cancer, and scientists have discovered that the spotted green-toed gutter snipe's tongue is crucial as an ingredient of a recently approved drug that seems to be producing remissions of that particular cancer. Suppose now that you don't own the land, but your neighbor does. Should the government be able to prevent habitat destruction? Should the government have to purchase that land from the owner to preserve the gutter snipe? And what would be the consequences of that option? The idea here is to get you thinking about some of the basic tensions of this chapter. The right to enjoy private property versus the need to preserve endangered species, and the question of how to pay for whatever balance is determined to be appropriate. Environmental regulation represents one of the most dynamic and contested areas of law today. What makes it particularly fascinating is how it forces us to confront fundamental tensions in our legal and ethical frameworks. The tension between property rights and ecological preservation sits at the heart of most environmental conflicts. When a landowner purchases property, what exactly are they buying? The absolute right to use that land however they wish? Or a bundle of rights constrained by a broader societal interest? Consider the recent controversy over Waters of the United States regulations. In January 23, the EPA and Army Corps of Engineers finalized a rule defining which waterways receive federal protection, reversing Trump-era rollbacks that had dramatically narrowed protection. Farmers and developers argued these regulations represented government overreach into the private property decisions, while environmentalists contended that interconnected water systems require comprehensive protection regardless of property lines. This ongoing regulatory back and forth perfectly illustrates how environmental law constantly negotiates this boundary between individual rights and collective interest. The Supreme Court's 2023 decision in Sackett versus EPA further complicated matters by limiting federal authority over certain wetlands, highlighting how these fundamental questions remain unresolved in our legal system. Courts have become critical forums for addressing climate change, particularly when legislative and executive actions stall. What's fascinating about climate litigation is how creative legal theories are being deployed to address an unprecedented global change. Juliana versus United States represents one of the most innovative approaches. Filed in 2015, by 21 youth plaintiffs, the lawsuit argued that government policies promoting fossil fuels violated their constitutional rights to life, liberty, and property by knowingly contributing to climate change. While the case was ultimately dismissed by the Ninth Circuit in 2020 on standing grounds, it established an important precedent by recognizing that climate change causes concrete, particularized injuries sufficient for standing purposes. In February 2024, the Biden administration forced a new lawsuit from youth activists challenging federal approval of the Willow oil drilling project in Alaska on constitutional grounds. This evolution of climate litigation demonstrates how the courts continue to be leveraged as tools for climate activism when other avenues appear blocked. Corporate accountability for environmental impacts has evolved dramatically from simple regulatory compliance to a much broader set of expectations from consumers, investors, and society. In 2019, the Massachusetts Attorney General filed a landmark lawsuit against ExxonMobil, alleging the company misled consumers and investors about climate change risks. What makes this case significant is that it relied on consumer protection law rather than environmental regulations, representing an innovative approach to corporate climate accountability. More recently, in March 2024, Engine Number One, a small hedge fund, won a proxy battle against ExxonMobil and secured 3 board seats on a platform focused on transitioning the company towards cleaner energy. This demonstrates how shareholder activism has become a powerful tool for pushing corporate environmental accountability. These developments reflect a fundamental shift in how we view corporate responsibility. It's no longer sufficient to simply follow regulations. Companies increasingly face scrutiny about their overall environmental footprint and climate impact. The Endangered Species Act of 1973 creates some of the most direct conflicts between property rights and environmental protection. When critical habitat is designated, property owners can suddenly find their development plans dramatically restricted or even prohibited entirely. Here's what makes this particularly thorny. Unlike eminent domain, where the government compensates property owners for taking their land, ESA restrictions typically don't trigger compensation requirements under the takings clause. This means private landowners bear the economic cost of species protection that benefits society as a whole. Let me give you a recent example that illustrates this tension perfectly. The property owner's dilemma. In Cedar Point Nursery versus Hassett in 2021, while not directly an ESA case, the Supreme Court addressed a related question about when government-imposed access to private property constitutes a taking requiring compensation. The court ruled that a California regulation allowing union organizers to access agricultural property constituted a per se physical taking requiring compensation. This decision potentially has significant implications for ESA enforcement, as it may expand circumstances where habitat protection could be considered a compensable taking. Consider the dilemma faced by Jack and Joel Holden, ranchers in Colorado, who discovered the endangered Preble's Meadow jumping mouse on their property in 2022. Suddenly, 40% of their land was designated critical habitat, preventing planned expansion of their cattle operation. While conservation easements offered some compensation, it didn't match the potential development value of their land. This case forces us to confront difficult questions. Is it fair to ask individual landowners to bear the full economic burden of species protection? Who should pay for conservation when the benefits are widely shared but the costs are narrowly concentrated? From the conservation perspective, species extinction represents an irreversible loss that cannot be measured solely in economic terms. Each species is the product of millions of years of evolution, with unique genetic information that once lost can never be recovered. My fictional spotted green-toed guttersnipe example may seem absurd, but it does underscore a crucial reality. We often don't know what we're losing until it's gone. The Pacific yew tree was once considered a trash tree of little value until researchers discovered its bark contained Taxol, a now crucial cancer-fighting compound. In December 2023, researchers announced that compounds found in the critically endangered Puerto Rican crested toad show promise as potential treatments for certain types of aggressive breast cancer. If this species had been allowed to go extinct before this discovery, that medical potential would have been permanently lost. This perspective argues that temporary economic interest must sometimes yield to permanent ecological losses, especially when extinction is forever. The ESA embodies this precautionary principle, essentially saying that when faced with irreversible consequences, we should err on the side of protection. The legal landscape around climate change has evolved dramatically over the past 2 decades. Let's examine how some key court cases have shaped this area. Massachusetts versus EPA 2007 established the foundation for climate regulation by confirming that greenhouse gases qualify as air pollutants under the Clean Air Act. This opened the door to EPA regulation of carbon emissions. Juliana versus the United States, as we've discussed, broke new ground by recognizing standing based on climate injuries, even though it was ultimately dismissed on other grounds. The Netherlands climate case in Urgenda Foundation versus the State of Netherlands represents a landmark decision where a court ordered a sovereign government to take specific climate action based on its duty of care to citizens. This case has inspired similar litigation worldwide. The Exxon investigation set the stage for holding corporations accountable, not just for emissions, but for potential fraud related to climate change knowledge. Let's talk more about the Exxon case. The Exxon case provides a fascinating study in corporate decision-making around climate science. Investigative reporting by Inside Climate News and the Los Angeles Times revealed that Exxon's own scientists accurately predicted climate change impacts as early as the 1970s and 1980s. The company invested significant resources, over $1 million, and years of research to understand climate change risks. Their findings were remarkably accurate, predicting temperature increases that align closely with what we've actually experienced. What makes this case ethically complex is the company's subsequent pivot. After understanding the science, Exxon allegedly funded climate denial organizations and publicly questioned the very science their own researchers had confirmed. In March of 24, a Massachusetts court rejected Exxon's final attempt to dismiss the state's fraud lawsuit, allowing the case to proceed to trial. This represents a significant development in holding corporations accountable for potential discrepancies between internal knowledge and public statements about climate change. This case also raises profound questions about corporate ethical responsibilities. Does a company have an obligation to share knowledge that might harm its business interests but benefit society? What responsibilities do corporations have to future generations? The regulation of pesticides that affect pollinators perfectly illustrates the challenges of applying the precautionary principle in environmental regulation. In 2013, the European Union implemented a moratorium on neonicotinoid pesticides based on evidence suggesting harm to bee populations. The United States took a different approach, developing a risk assessment framework rather than an outright ban. The sulfoxaflor case demonstrates the tension between scientific uncertainty and regulatory action. Initial Tier 1 testing showed concerning impacts on bees, but the EPA approved the pesticide despite incomplete Tier 2 testing. In 2022, the EPA announced it would withdraw approval for 12 neonicotinoid pesticides as part of a legal settlement with environmental groups. This represents a significant shift towards greater precaution in pollinator protection. And this case demonstrates how scientific uncertainty often intersects with regulatory decisions. When faced with incomplete data about environmental risks, should regulators err on the side of economic interest or environmental protection? John Locke's property theory provides a fascinating framework for examining environmental conflicts. His labor theory suggests that by mixing our labor with natural resources, we create a right to ownership. But what's often overlooked in discussions of Locke is his crucial limitation. Ownership is only justified when there is enough and as good left in common for others. This proviso raises profound questions in an age of environmental scarcity. For example, if a company claims water rights in a drought-stricken region, can they truly satisfy Locke's proviso? Is there, quote, enough and as good, end quote, left for others when resources become limited? Locke also warned against waste, arguing that property rights extend only to what one can use before it spoils. While he accepted accumulation through trade and money, this principle could be interpreted as supporting sustainability, taking only what we can use without waste. Finally, Locke's view that government exists primarily to protect property rights conflicts with modern environmental regulation. If we accept Locke's framework, but expand our understanding of the proviso to include future generations, how might that reshape our approach to environmental law? The rights of nature movement represents a radical reimagining of our legal relationship with the natural world. Rather than viewing nature as a property to be owned and used, this perspective recognizes nature as a rights-bearing entity deserving legal protection in its own right. Now, this isn't merely theoretical. Ecuador's 2008 Constitution explicitly recognizes the rights of nature, stating that nature, or Pachamama, where life is reproduced and exists, has the right to exist, persist, maintain, and regenerate its vital life cycles, structure, functions, and its process and evolution. In 2017, New Zealand granted legal personhood to the Wanganui River, recognizing it as an indivisible and living whole, with its own rights and interests. This followed similar recognition for the Te Urewera Forest in 2014. In the United States, several municipalities have passed local ordinances recognizing rights of nature, though these have faced legal challenges. The Pennsylvania Supreme Court struck down such an ordinance in 2020, highlighting the ongoing tension between this emerging philosophy and having traditional property rights. This movement asks us to fundamentally reconsider how we understand our relationship with nature, not as owner and property, but as interdependent beings sharing a common ecosystem. Pope Francis's 2015 encyclical Laudato Si represents one of the most significant religious statements on environmental ethics in recent history. What makes it particularly noteworthy is how it frames environmental protection not as a political issue, but as a moral imperative. The encyclical introduces the concept of integral ecology, arguing that environmental problems cannot be separated from social justice concerns. Environmental degradation and poverty are interconnected crises requiring holistic solutions. In May 2023, Pope Francis updated his teachings in Laudate Deum, specifically addressing climate change as a global emergency requiring immediate action. He criticized weak international responses and called climate change denialism no longer tenable. This framework offers a different approach to environmental ethics, one grounded not in property rights or economic value, but in moral responsibility and spiritual obligation. It asks us to consider our relationship with nature as part of a broader web of ethical responsibilities to each other and to future generations. The Fifth Amendment's taking clause, "Nor shall private property be taken for public use without just compensation," represents the constitutional fulcrum on which many environmental disputes balance. What exactly constitutes a taking requiring compensation? The Supreme Court has developed a complex framework addressing different types of government actions. Physical invasions, even minor ones, generally require compensation. In Cedar Point Nursery versus Hassett in 2021, the court ruled that even temporary access requirements can constitute per se takings requiring compensation. Regulatory takings are more complex. When regulations eliminate all economically beneficial use of a property, as in Lucas versus South Carolina Coastal Council, they generally require compensation. But when regulations merely reduce property value, courts apply a multi-factor balancing test from Penn Central Transportation Company versus New York City. The nuisance exception provides that no compensation is required when regulations prevent uses that would be prohibited under common law nuisance principles. This creates a crucial escape valve for environmental regulations. Lucas represents a landmark case in regulatory takings jurisprudence with profound implications for environmental regulation. David Lucas purchased 2 beachfront lots on South Carolina's Isle of Palms for $975,000, intending to build homes. After his purchase, South Carolina passed the Beachfront Management Act, prohibiting construction in areas experiencing erosion, including Lucas's lots. Lucas sued, claiming the regulation constituted a taking requiring compensation. The Supreme Court ruled that when regulations eliminate all economically beneficial use of a property, they constitute a per se taking requiring compensation, unless the regulated activity would constitute a nuisance under state common law. In March 2023, the case gained renewed relevance when the South Carolina legislature considered a Lucas bill that would require compensation for any regulation reducing property value by more than 15%. Environmental groups opposed the bill, arguing it would effectively prevent the state from implementing necessary environmental protections. This case illustrates the ongoing tension between property rights and environmental protection, particularly in vulnerable coastal areas facing climate change impacts. The majority in the Lucas case portrayed Lucas as a property owner who paid nearly $1 million for residential lots intending to build homes, like his neighbors before new regulations prevented all development. The dissent characterized Lucas as a developer who bought unstable beachfront property knowing regulations were imminent, noting the land had been underwater for years during the previous decades. The court ruled that when regulations limit all economically beneficial use of land, compensation is required unless the prohibited use would have been unlawful under background principles of property law. Now, the Supreme Court has developed a complex framework for determining when environmental regulations constitute a taking requiring compensation. So let's break down these key categories. Physical invasion. Any government-authorized physical occupation of a property requires compensation. In Cedar Point Nursery in 2021, the court expanded this category to include even temporary access requirements. Total economic loss. Regulations that eliminate all economically beneficial use of land require compensation under Lucas, unless they prohibit uses that would constitute a nuisance under state common law. Nuisance prevention. No compensation is required when regulations prevent uses that would be prohibited under common law nuisance principles. This creates a crucial exception for many environmental regulations. Partial diminution. When regulations reduce but don't eliminate property value, courts apply the Penn Central balancing test, considering factors like the economic impact, inference with investment-backed expectations, and the character of government action. In April 2024, the Supreme Court heard arguments in Sheets versus County of El Dorado, examining whether development impact fees can constitute a taking. This case could potentially reshape how courts evaluate regulatory takings claims, with significant implications for environmental regulations. The environmental justice movement emerged from the recognition that environmental burdens are not disturbed equally across society. Communities of color and low-income neighborhoods disproportionately bear the impacts of pollution, toxic waste, and environmental degradation. This movement traces its origins to Warren County, North Carolina, back in 1982, when predominantly black residents protested by the sitting of a PCB landfill in their community. These protests sparked a national conversation about race, class, and environmental risk. Unlike traditional movements that focus primarily on wilderness preservation and wildlife conservation, environmental justice centers on human communities and the disproportionate risk they face. In January 2023, the Biden administration launched a new environmental justice office within EPA to address these disparities. The office oversees distribution of $3 billion in environmental justice grants created under the Inflation Reduction Act. In April 2024, the EPA finalized its Environmental Justice in Permitting Rule, requiring states to consider environmental justice impacts when issuing air pollution permits. Industry groups immediately challenged the rule, highlighting the ongoing tension between environmental justice principles and business interests. The food justice movement represents an extension of environmental justice principles into our food systems. It recognizes that access to healthy, sustainable food is unequally distributed and intertwined with broader systems of social inequity. This movement addresses food deserts, areas where residents lack access to affordable, nutritious food. A 2023 USDA report found that 19 million Americans live in low-income areas more than a mile from the nearest supermarket, with these areas disproportionately located in communities of color. In response, innovative solutions have emerged. The Detroit Black Community Food Security Network has developed urban farms and a food co-op to address food access issues while building community ownership of food systems. Corporate responses have been mixed. In 2023, Walmart announced a commitment to open stores in underserved communities, yet critics note that the entry of large retailers can sometimes undermine local food businesses. The food justice movement highlights how environmental justice extends beyond traditional pollution concerns to encompass the full spectrum of how communities interact with their environment, including through food production and consumption. Food policy councils, FPCs, represent an innovative governance approach that brings diverse stakeholders together to address food system challenges. They typically include farmers, consumers, retailers, nutritionists, and policymakers, working collaboratively on local food policy. There are now over 300 FPCs across North America, operating at city, county, and state levels. The Los Angeles Food Policy Council, established in 2011, has successfully advocated for urban agriculture incentive zones, healthy food procurement policies for public institutions, and programs connecting small farmers with institutional buyers. In March 2024, the Baltimore Food Policy Council helped pass legislation creating tax incentives for grocery stores opening in food desert communities, demonstrating how these bodies can translate community needs into concrete policy changes. FPCs represent a collaborative approach to food system governance, bringing together stakeholders who might otherwise work in isolation or opposition. This model offers valuable lessons for other areas of environmental governance where diverse interests must be balanced. The Clean Power Plan represents a fascinating case. I keep saying that. All of these cases are fascinating, right? In the challenges of implementing ambitious climate policy. Announced in 2015, it aimed to cut power plant emissions by 32% below 2005 levels, and the goal was to implement this by 2030, primarily by shifting from coal to cleaner energy sources. Now, this plan faced immediate legal challenges, with 27 states and numerous industry groups filing lawsuits challenging EPA authority. In an unprecedented move, the Supreme Court stayed implementation before the lower courts even ruled on the merits. The Trump administration subsequently repealed the plan and replaced it with a much less stringent Affordable Clean Energy rule. This regulatory back and forth illustrates the vulnerability of executive climate action without legislative backing. In 2022, the Supreme Court severely limited EPA's authority to regulate greenhouse gas emissions from power plants in West Virginia versus EPA, ruling that major questions of economic and political significance require clear congressional authorization. This history demonstrates how climate policy remains contested terrain, with courts playing a crucial role in determining the boundaries of executive authority to address climate change in the absence of comprehensive legislation. Corporate environmental commitments have evolved dramatically over the past decade, moving from peripheral CSR initiatives to core strategic considerations. Let's examine different ethical perspectives on these commitments. From Milton Friedman's free market perspective, environmental initiatives are justified only when they enhance shareholder value through cost savings, customer goodwill, or risk reduction. Many companies frame their commitments to these terms, emphasizing the business case for sustainability. A utilitarian approach evaluates corporate environmental commitments based on whether they produce the greatest good for the greatest number. This might justify more ambitious commitments that reduce overall environmental harm, even if they temporarily reduce profits. Deontological ethics would focus on duties and intentions, asking whether corporations have moral obligations to protect the environment regardless of financial outcomes. This perspective might support environmental commitments as a matter of principle rather than profit. Virtue ethics focuses on character and values, suggesting that corporate environmental stewardship reflects and builds corporate virtue. Companies like Patagonia embody this approach, making their environmental values central to their corporate identity. Now, in practice, most corporate environmental commitments reflect a blend of these perspectives, balancing business interests with broader environmental responsibilities. The fossil fuel divestment movement on university campuses offers an interesting lens for examining how institutions navigate competing ethical, financial, and social responsibilities. Urban environmental justice issues reveal how environmental burdens intersect with race, class, and power in city settings. The Los Angeles oil drilling example perfectly illustrates these dynamics. Despite its reputation as an environmentally progressive city, Los Angeles has over 1,000 active oil wells within city limits, many in densely populated neighborhoods. A 2021 study found that these wells are disproportionately located in low-income communities and communities of color. A 2015 lawsuit challenged the city's permitting practices, alleging that officials allowed more polluting diesel drilling operations in predominantly Black and Latino neighborhoods while requiring cleaner electric rigs in wealthier, whiter areas. In December 2022, the Los Angeles City Council voted unanimously to phase out oil drilling within the city limits, with existing wells to be decommissioned over a 20-year period. This represents a victory for environmental justice advocates. Similar patterns emerge in other urban settings. In March 2024, Chicago's Southeast Side community won a significant victory when the city denied a permit for a metal shredding facility following community opposition based on cumulative pollution burden in a predominantly Latino and Black neighborhood. These cases demonstrate how environmental justice advocacy is reshaping urban environmental governance, forcing cities to consider equity alongside traditional environmental concerns. As we conclude today's lecture, I want to emphasize several key themes that run throughout these complex intersections of law, ethics, and business interests. First, environmental law continues to navigate the fundamental tension between private property rights and collective environmental interests. This tension isn't just simply resolved, it requires ongoing negotiation and balance that reflects evolving values and scientific understanding. Second, courts have emerged as crucial arbiters in environmental disputes, particularly around climate change. When legislative action stalls or executive policies fluctuate, judicial forums provide continuity and develop legal frameworks for addressing environmental challenges. Third, corporate environmental responsibility has expanded dramatically beyond simple regulatory compliance to encompass broader expectations from investors, consumers, and society. Companies increasingly face scrutiny not just for legal violations, but for their overall environmental footprint and environmental impact. Finally, environmental justice has reshaped how we evaluate environmental policies, adding equity considerations to traditional environmental concerns. The fair distribution of environmental burdens and benefits has become an essential element of environmental governance. As future business leaders and policymakers, you'll navigate these competing values and perspectives. There are rarely simple answers in this field. Instead, you'll need to thoughtfully balance legitimate interests while recognizing our collective responsibility to protect the natural systems that sustain us all.